All right, welcome once again. As the title says, Disability Law Show is here. 30 minutes of great information and education for you. John Skoll is here. Beside me, James Fireman, Samfiru, Tumarkin, LLP, the most positively reviewed disability law firm in the land. Every week, James answers all of your questions. Several different ways to reach out to get your stuff on the show or otherwise after the show. 1-855-821-5900 would be that number, and help@disabilityrights.ca. On the show today, 5 crucial things you must do if your long-term disability benefits have been cut off. 5 things. We'll get to that in just a little bit. James, there's also mydisabilityquestions.com. I want to mention that website because we might use that as well today. That is free, anonymous, and completely searchable. So your question may have been asked in the past. You can type it in and look. If not, leave it. James and a member of his team are quick to answer them all. mydisabilityquestions.com. But lots of stuff to get through on the show today, James, as always. But a situation you've been working on. What do you got?
Well, I thought I'd go in a little bit of a different route this week. I was contacted by a former client, a very nice lady that I helped resolve a disability claim last year, and we got a very nice settlement. But there was an issue that came up with her file, and she reached out for some help afterwards. And so I thought it might be a good opportunity to discuss what happens after your claim has been resolved. And I don't mean the nuts and bolts of finishing off the settlement, although if you're wondering, usually after we get a resolution, it's about 3 or 4 weeks before the money is in the client's hand. There are a few documents to sign, but nothing terribly onerous. Really what I wanted to talk about is what happens generally going forward when issues arise. And the types of things that we see very commonly for people who have had disability claims that we've been retained on usually involves their employer. So typically speaking, a lot of our clients are under a group disability plan, a plan where their employer is the policyholder. And because of that, when you go on disability, your employer is notified of that claim. And whatever changes there are to your status after you apply, the employer is notified of the change of status. They don't get your medical information, but they know where you are in the process. So they get notified that you've applied, and they get notified of your insurer's decision. And if they deny, and then we bring a claim against your insurer, a legal claim, they're notified that you're in the legal claim process. And then if we get a settlement, your employer is notified of that as well, which eventually leads to a, hey, what's up letter from your employer. That's what I usually refer to it as. So your employer reaching out and asking, okay, well, we understand that you've resolved your disability claim. What's happening with work now? When are you planning on coming back? And so the answer to that, the best route to go, is going to depend on my client and on their disability. If my client happens to be in a position where their disability has improved to the point where they're contemplating a return to work either now or in the near future, then it's simple enough. You advise the employer of that situation and what the parameters are and of the limitations and restrictions, and hopefully you're able to get a return to work plan. But in other situations where the client remains disabled indefinitely, then that's an issue because you want to make sure that you're in the best position possible if you have to talk about a termination or a frustration of contract situation, which is why having a firm like ours, where we have a focus both on disability and employment law, really comes in handy. And so when this happens, invariably I'm going to reach out to Lior or one of my other partners on the employment side and set my former clients up with a consultation with a great employment lawyer who's going to be able to guide them through that process, depending on what the intricacies are of their particular situation with their employer. But then there are also other situations that come up. And generally speaking, once I've represented someone and I've gotten them a good resolution, I will usually hear from them at some point down the road if they have any other legal issues that come up. And it's not with the expectation that I'm going to represent them if they, get involved in, some construction lien issue or a family law matter, but they're coming to me because they know I'm a lawyer and they know that I probably have contacts in other areas. And so they're really just asking me for advice for a referral. Who might I go see to do this? Who would you trust to handle this sort of issue? I'm always happy to help in that situation. And then occasionally there are issues like the lady I was talking about at the outset who contacted me in the last few weeks, where she had an issue with a letter that the insurer had written to her pension board, which is something that I can't get involved in. But what happened is the letter written by the insurer, the disability insurer, put the wrong date for the start of her disability. And that had a potential impact on her relationship with her employer. And so because of that, she was at a bit of a loss for what to do. So she gave me a call, and I was able to resolve it for her within a couple of days, simply by picking up the phone and speaking with the lawyer I had dealt with at the insurer. They fixed the letter, she got the date corrected, and everything was okay. All of which is to say that, in my view, good service is a lifetime commitment. It means that if I'm your lawyer, you're going to be able to call me, and whatever I can do to help you down the road, I'm going to make sure happens.
Yeah, it's an interesting case. People sometimes make that crossover between, losing their job and ending benefits. I mean, although the benefits may be partially paid by your employer, the insurance company, you're dealing with them, i.e. dealing with you, is completely different. And only when those two converge is when you got to give Leora a call, the other side of the hallway, where you guys do employment law. That's when that comes into play, right?
Yeah, and it's incredibly helpful to have a firm that has expertise in both areas, because there are so many different ways that those two areas can intersect, and it can cause so many different issues that if you only have a casual knowledge of the other side, the side that you don't typically practice on, then you could be in for some trouble. Me, for example, I don't handle employment law issues. It's just not my area of expertise. Working in the disability field and working closely with employment lawyers for so long, I've got a pretty good understanding about what goes on, but I just don't have the depth of knowledge in employment law that someone like Leora and the other lawyers at our firm has. And that's why it's just such a great marriage of expertise.
Which is a great time to mention Pocket Employment Lawyer. Nice how we slid into that. It's like we've done this before. PocketEmploymentLawyer.ca is a website we use all the time in the Employment Law Show with Leora. We talk about it. And even though it's about employment law, basically that's what it's structured on. There is a section on disability law because, to James' point, there's a lot of crossover between the two, so that could be a help of you as well. Even before the phone call to James, possibly go to PocketEmploymentLawyer.ca, look for the disability tab, and read up. You might learn something that might solve your problem. But I want to get to an email now, James. Again, help@disabilityrights.ca is the email address we use all the time. You can use it anytime. This is from Gregory. Writes in, says, I was in a serious accident almost a year ago that resulted in a shoulder injury and ongoing migraines that prevented me from being able to work. I applied for LTD but was denied because I'm not, quote unquote, totally disabled. My doctor believes I need to continue with ongoing treatments and that I'm not yet able to return to my job. What are my options?
Bring a legal claim. Gregory, that's what your options are. We want to bring, the insurance company will tell you you can appeal, but forget that. Your option is to bring a legal claim if you want to get a reasonable result and get your benefits restored. I want to go to a particular phrase that Gregory mentioned, which was the basis for the denial. Yep. And it's that phrase, totally disabled, which we see in virtually all long-term disability policies. And it's language that's used very deliberately, because when you say the phrase, totally disabled, it conjures up the image of somebody who cannot get out of bed, who can't make a meal for themselves, needs help bathing, needs help to feed their goldfish. They can't go shopping for themselves. That's what we think of when we think of someone who we would call totally disabled. That is in no way what it means under long-term disability. All it means in a long-term disability claim is that you are disabled from being able to do your own occupation. That's all that it means. You very well might be disabled from your own occupation and still be able to do a lot of things for yourself. You may still be able to drive. You still may be able to cook. You still may be able to go shopping for yourself. You may be able to do all sorts of activities of daily living and still not be able to function in your job and thus still be entitled for benefits. The reason they use the phrase totally disabled is too misleading. It's so that when they say you're not getting your benefits because you're not totally disabled, a lot of people who don't understand that that's not what it means in the context of a policy are going to say, well, I guess they're right. I'm not totally disabled. I can still do a lot of things. I can still drive myself. I can still cook for myself. So I guess I'm not entitled to benefits. And that's where they leave it. That's what the insurance company wants you to do. That's why they use that particular phrase. There's no reason to use that phrase. They could just say disabled from work. That could be the language. There is, a very deliberate purpose to using that phrase, and that purpose is to mislead you.
Yeah, it's interesting too, because I can imagine that would strike people as, okay, I guess I have no choice if it's something, as we mentioned before, with a mental health issue, where it doesn't come up on a CT scan or an X-ray, but you may be totally disabled due to that mental illness and you can't do your job, but you're still going to hear that language, right?
Yeah, and I find this even more insidious in mental health issues, because here you're talking a lot of times people who are suffering from significant anxiety. And so for them to even start this type of process, for people who are suffering from significant emotional and mental health issues, it's already very difficult for them mentally just to begin that process. And if you're using language that's deliberately designed to deceive, then I think that really underscores what the intention is for an insurance company and what they're really focusing on. And that's just their own bottom line. That's all.
What we want to get to after the break is 5 crucial things you must do if your LTD benefits have been cut off. So we will do that. In the meantime, here is the number to write down and keep with you to call James and his team. 1-855-821-5900, or send along an email, help@disabilityrights.ca. More Disability Law Show is coming up. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back, and thank you for sticking with us here on the Disability Law Show. James Fireman here once again from Samfiru, Tumarkin, LLP. They are the most positively reviewed disability law firm in the land, have helped thousands of people get the compensation they deserve. They are owed. It is not a lottery ticket. This is the insurance. This is your coverage. So reach out to James anytime there's discrepancy or you feel like you're being overwhelmed with a cutoff by your insurance company. 1-855-821-5900. But James, let's get into these talking points. 5 crucial things you must do if you've been cut off your LTD benefits. Number 1, do not take the insurance company's decision at face value, right?
Yeah, listen, it sounds like common sense, but really the insurance companies spend millions of dollars a year trying to get you to believe that they're your pal, that they're there to look out for your best interest. They're, the good neighbor. You're in good hands. That when you have a problem, they're the ones to turn to. They're going to be there for you. They are corporations. They are there to serve their shareholders. They're there to make a profit, nothing else. Now, that doesn't mean that you have to be antagonistic with them. Doesn't mean that you have to be impolite, but you do have to remember when you start the process and when you're involved in the process, they have an agenda. They have a deliberate purpose to try and cut off or deny benefits as soon as they can in order to generate more profits. That's what they're there to do. They don't know more than you're treating doctors. And so if your treating doctors are telling you one thing and the insurance company is not accepting that, they're telling you something else, rely on your treating doctors. And if the insurance company cuts off your benefits or deny your claim, don't accept that they're right. They almost certainly are not.
Number 2 thing you must do if you've been cut off by your insurance company is this: check your disability policy, which you should know like your best friend, to determine if your benefits should and can continue. How about that?
Sure. And, in the context of most denials, when you're talking about not meeting the definition of totally disabled, it's very much in line with what we've been talking about the entire show, whether you have a disability that prevents you from being able from working. So again, this is going back to what your doctors are telling you. But there are other situations where it can apply, where it might be really crucial that you take a look at your specific disability policy. There can be technical denials for things like a pre-existing exclusion, or perhaps they're saying that you moved out of jurisdiction and you're not allowed to. If they're denying you for anything like that, you want to make sure that anything that they're relying on is actually in the policy explicitly. If it isn't explicit in the policy, then they can't rely on it. Likewise, if they're saying that you're entitled to benefits, but they're entitled to deduct money that you're receiving from some other source. If they're telling you that, then it has to be explicitly in the policy. And if it isn't, they're not entitled to deduct that money. So make sure you look at the policy. And if you can't find the thing that they are relying on, what your insurance company is telling you is the basis for their denial or the set-off, ask them to point you to exactly where in the policy it says what they say is the basis for their decision.
You know, it's interesting, and that dovetails nicely into the next point. You mentioned money is coming in from other sources, and that is you should apply for CPP disability if you have not done so already. This is important as well.
Very important. So CPP disability is, of course, a program run by the federal government under the Canada Pension Plan. It applies for anybody who has a disability that has been paying into CPP for, I believe, at least 4 of the previous 6 years. And if you meet the test under CPP disability, which is a severe and prolonged disability, then you're entitled to monthly benefits. Now, those benefits are usually an offset against what your insurer is required to pay you. So if you're entitled to $4,000 a month from long-term disability, and CPPD approves your claim for $1,000 a month, then you get $1,000 from CPP, and you get $3,000 difference from your long-term disability insurer. So you're not actually getting any more money if you're approved, but there are a lot of reasons why it's to your benefit to apply and hopefully be approved. One, the test for CPP disability is a more difficult test. So if you pass the test, if the government says that you are disabled under CPP disability, it is very difficult for your insurance company to take the position that you are not disabled under their test, which is not as difficult as the CPPD test. The other nice benefit is that when you're approved for CPPD, if your long-term disability insurer cuts off your benefits down the road, you have another source of income coming in. So you're not relying on just one insurer in order to get that monthly amount. It's divided, so you're more likely to at least get something at any point down the road. And the third thing is, even if you are denied, at the very least, your insurer is not then entitled to say that had you applied, you would have been approved, and therefore they're taking their estimate of what your benefit amount would have been if you applied. I know that's a little convoluted, but to put it differently, if you don't apply, your insurer can reduce your benefits. If you do and you're denied, they can't do it.
Fourth thing you need to do, we're talking about crucial things you need to do if you've been denied or cut off your LTD from your insurer, and that is confirm your doctor's support in writing. We like everything in writing, that you're still unable to work.
Sure. This is the crucial variable whenever I'm speaking with a new potential client. It's the one thing I really want to understand. What are your doctors telling you? What have they said about your ability to work? Do they support that you are not able to return to your occupation or beyond 2 years to any occupation? That's really what I want to find out. Is that in writing? If it's not, make sure your doctor puts it in writing. And as I've spoken about at length on this episode and on other episodes, it's really important that that is translated into your functional abilities. You know, what is your ability to, you know, if it's a physical issue, to sit for an extended period of time or stand for an extended period of time? If you have mental health or cognitive issues, what is your ability to concentrate or focus or multitask or whatever else it is that is preventing you from being able to return to work? Whatever those functional limitations are, it's really important that your doctor take the time and reduce that to writing and provide that to your insurance company. One, that's going to make it much more difficult for your insurer to deny a claim. But two, if they do, it puts you in a much better position down the road when you bring a legal claim to challenge the denial or termination of benefits.
And the fifth and final thing you should do, the obvious one, is pick up a phone, write an email, speak to James, your disability lawyer, to clear things up about your situation. Get some information.
Yeah, absolutely. And as I say, every time this comes up, it's a free consultation. So you really don't have anything to lose by calling. No one's going to ask for your credit card. You can be anonymous if you'd like initially. And even during the consultation, even if we send you the retainer package, you don't have to do anything with it. It's just about gathering information so you can figure out what your options are and make the decision that's going to be best for you.
Want to take a quick break, James, and we'll get back into more of our content. Email address in the meantime, help@disabilityrights.ca. That's the one we use every show. And the phone number to reach out, like we just mentioned, 1-855-821-5900. More Disability Law Show coming right up. Don't go anywhere.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, welcome back. Thanks. Let's carry on. I mentioned several ways to get in touch with James and his team throughout the show. First, the phone number, 1-855-821-5900. Email address, help@disabilityrights.ca. And there's another way, free and anonymous website, a place for you to type in your questions and ask them. You can search to see if your question has been asked or one similar. That's the way the algorithm works, called mydisabilityquestions.com. James, we'll get to the first one for the show today. This is from Trevor, writes again at mydisabilityquestions.com. Trevor says, after contracting COVID-19 at the start of the pandemic, I began experiencing several symptoms associated with long COVID that severely impacted my ability to function. I tried to get LTD benefits, but was rejected over lack of medical documentation. I have appealed twice, unsuccessfully. Should I try again?
All right, I'm going to have to deal with that appeal part right at the end there first, John. So the answer, should you appeal again? No, unless you enjoy wasting your time. There's really no reason to continue in that appeal cycle over and over again. All you're doing is you're allowing the insurance company to maintain control over the process, even when they're not paying the benefits that they're required to under the policy. There's no reason to do that. If you want to challenge their decision, then you should be bringing a legal claim. But I want to talk specifically about the issues Trevor is facing, specifically dealing with having contracted COVID-19 and then suffering from the long haul symptoms. So, Trevor didn't mention what his symptoms were in this case, but I've had several clients with similar types of issues. And what comes up time and again, extreme fatigue, cognitive issues, headaches, overall body pain. This is what we see. This is what I see all the time. And it is what's generally reported for people who are suffering from long haul COVID. Whether you have long haul COVID or some other disease is really kind of irrelevant from a legal context. From the medical context, of course, it matters greatly. But from a legal context, that's really not what the focus is. It doesn't matter whether there's a diagnosis at all. This is what we talk about all the time. The focus is on your functional abilities, on your symptoms. How do your symptoms prevent you from being able to function in a work environment? And if they are not allowing you to substantially fulfill the responsibilities of your occupation, then you're entitled to benefits. That's the way the policy works. Whether it's from long COVID or some other disease or from something that's a complete mystery, if you are suffering from symptoms that prevent you from work, you're entitled, even where there's no test that can confirm it. So in Trevor's situation, it sounds as though he was actually diagnosed with COVID. He tested positive for it. And so, that probably helps a little bit. in terms of explaining what's gone on, how his situation has arisen. And so it is something that can be somewhat helpful when we dispute the decision in a legal claim, but it's certainly not necessary. And so if someone is out there that has contracted COVID or believes they have contracted COVID, but weren't able to get a test to confirm, and then subsequently begin suffering from long haul symptoms, it doesn't mean because you didn't actually test positive, because you weren't able to access a test or for whatever reason did not test positive at any point. That doesn't mean you're not entitled to benefits. You are if you are suffering from symptoms that are preventing you from working. And as we know, right now it's very difficult to get a PCR test to confirm whether or not you're entitled to benefits. That's changing, or whether or not you're COVID positive. That changes. That may change over time. It may be easier down the road. It certainly had been easier in the past. But whether or not you actually have a test that shows that you are positive for COVID-19, if you're suffering from long haul symptoms and they're preventing you from working, you're entitled to benefits.
I want to go to an email next, James. It's anytime help@disabilityrights.ca. Sina writes in, says, I was originally on LTD due to ongoing knee and back problems. After several surgeries, I was also diagnosed with severe neck stenosis. Am I required to inform the insurance company that I now have additional conditions?
Well, required isn't the word I would use, but you certainly ought to tell them. There's no reason why you shouldn't tell them that. It only improves your disability claim down the road. What you need to remember, and I was just talking about this in Trevor's case, it isn't about a particular diagnosis. So whether your initial issues were knee and back pain and now it's neck stenosis, that doesn't mean that all of a sudden it requires a new claim or it's not relevant to your existing claim. Because your existing claim isn't about knee and back problems. It is about your functional limitations in your ability to work. And additional neck problems added to your knee problems and back problems just makes it more difficult for you to be able to work and confirms that you're now even less likely to be able to return to work. So absolutely, it is something that you should be sharing with them. Remember, your disability can certainly change over time. If your initial disability is physical, what we see very often is it can develop into a psychological issue as well. And if it's significant enough, if you're suffering from significant emotional and psychological issues, even after your physical issues resolve, you might still be entitled to disability benefits if your psychological and emotional issues are functionally limiting you from being able to return to work. So it's certainly not the case that you're stuck in one lane just because this is what your disability looked like at the outset. And by all means, you should absolutely advise them of the additional issues that you're having, any additional diagnoses, any additional testing that shows what is going on. Let them know.
I want to get to Tiago really quick. Again, mydisabilityquestions.com in our last minute here. Tiago says, my insurance adjuster has just informed me that my file will be reviewed by a health management consultant. What does this mean, and do I have to follow this consultant's recommendations?
Well, it doesn't necessarily mean anything. A health management consultant means whatever the insurance company says it means. Sometimes it is a doctor, sometimes it's a nurse, sometimes it's someone else who knows. If it is a doctor, usually it's not someone who has specialized expertise. Usually it's a general practitioner who they're relying on just to review your file, the paper file, and provide them with an opinion about what's going on in your claim. That is by no means a stronger opinion than that of your treating doctors who have seen you in person, who have known you for years, who understand your full medical condition. So it is really just a very cursory opinion that insurers rely on in order to justify their position.
And that is it for another show. James, thank you, and thank you for your contributions as well. Reaching out, 1-855-821-5900 and help@disabilityrights.ca. We'll catch you next time, Disability Law Show.